Welcome to all the students once again. In the previous video, we have seen the background and the features of the Companies Act 2013. Further, we have studied the meaning and definition of company, features of the company, and the distinction between a company and a partnership firm. Today, we will see the next topic of the first chapter, that is types of companies. This topic, types of companies, I have divided into two parts, and today we will see the first part. So let us begin the types of companies. Okay, there are various types of company which we'll be seeing here. That is why I have divided the lecture into two parts. Okay, so let us see the types of companies. See, on the basis of formation, there are two types of companies. First one is statutory company and registered company. Okay, on the basis of number of members, again there is a two type, that is public company and private company. Next, on the basis of liability, you can see the three types of company, that is company limited by shares, company limited by guarantee, and unlimited companies. Okay. Further type you will see on the basis of control. On the basis of control, there are three types: holding company, subsidiary company, and associate company. And the last comes other kinds of companies, which include one-person company, charitable companies, dormant companies, sick company, small company, listed companies, and foreign company. So these are the various types of companies on the basis of formation, number of members, liability, control, and other kinds of companies. So today in this part 1 of types of companies, we will see on the basis of formation and the number of members. So let us begin with the first, that is on the basis of mode of formation. On the basis of mode of formation, there are two types of companies, statutory and the registered. So what is statutory companies? Companies which are created by a special legislation of Parliament or state legislature may be called statutory companies. Example, Life Insurance Corporation of India, RBI, etc. These companies are formed mainly with an intention to provide the public services. So the statutory companies are those companies which are formed by a special act of Parliament or by a state legislature. For example, life insurance, your RBI, they are formed by the government. But the rules of the Companies Act 2013 are also applicable to these kind of companies, along with the rules of the Parliament or rules of the government. Okay. Now next comes registered companies. Companies registered with the Registrar of Companies under the Companies Act 2013 or under any previous company law are called registered companies. So registered companies are those companies which are registered with the Registrar of Companies under the Companies Act 2013 or under any previous law or under any previous company law. So these companies are called as registered companies. Okay. All the companies in India existing except the statutory companies have been formed in this manner. So whatever the companies which are there in India are established or are formed under registered companies only. Exception is given to the statutory companies which are formed with the special legislation of Parliament. Okay. For example, Reliance Industries, Tata Iron and Steel Company, etc. Whatever the companies which are established in India are formed under the Companies Act 2013 only or under any previous law, and they are termed as registered companies. Okay. Now next comes on the basis of number of members. On the basis of number of members, first one is your public company. So according to the section 2 subsection 71 of the Companies Act 2013, a public company means a company which is not a private company or has a minimum paid up capital of rupees 5 lakhs or such higher paid up capital as may be prescribed. And third, provided that a company which is subsidiary of a company, not being a private company, shall be deemed to be a public company for the purposes of this act. So public company basically is that company which is not a private company or which has a minimum paid up capital of rupees 5 lakh, or it can be a high amount also. Okay, so this is the definition given under the Companies Act 2013 under the section 2 subsection 71. Okay. Now let us see the advantages of a public company. What are the advantages? First one is your limited liability. See, shareholders are only limited by the value of shares they hold. So whatever the value of shares the shareholders are holding, to that much amount only the liability is limited. Okay. The next point is a company can sue and be sued in its own name. So it means as a separate legal entity, that is an imaginary person, the company can sue and can be sued outside of its owners. Okay. Now comes can issue shares to the general public. See, public companies are allowed to issue the shares to the general public. Means the general public like us, we can subscribe to the shares of a public company. Okay. Now unlimited capital investment opportunities. What does it mean that unlimited capital investment opportunities? See, the public limited company has a greater pool of capital, that is sources of capital. This is because it has no limits to the number of people who can be shareholders and can sell its shares to the public on the stock exchanges. Also, the company has a greater capacity to raise loans from financial institutions such as banks and through debentures. That is why it is called as unlimited capital investment opportunities. Okay, now comes transferability of shares. See, in public limited companies shares can be easily transferred from one member to another. Okay. Now next comes members of the public have access to information of the company. Yes, members of the public means we. The members of the public have information on the company, since the company's books of accounts are published for all to see. And this helps to make the better decision concerning the company, such as whether or not to buy shares from the company or not. So these were the advantages of the public company. Next comes your disadvantages. See, more compliances than private. To form a public company, more compliances or more steps of formations are needed as you compare to the private company. Okay? There are more legal formalities are formed, or there are more legal formalities are there as compared to the other forms of company if you have to set up a public company. Annual general meetings are compulsory to be held. Okay? And there should be a higher level of transparency required. Means the accounts are to be verified. Okay? It is very necessary. Then comes need to have 3 directors and minimum rupees 5 lakh as minimum capital. To form a public company, you should have a 3 directors minimum, and a paid up capital should be rupees 5 lakh. If you compare this amount in case of private company, it is 1 lakh. So it means that there is some compliances, or there are some stages, or there are some formalities which are more than the private company in the formation of a public company. Okay. Now next comes your private company. So according to section 2 subsection 68, private company means a company which has minimum paid up capital of 1 lakh rupees or such higher paid up capital as may be prescribed by its articles. So what I said, so minimum paid up capital in case of private company is what? It is 1 lakh. As compared to the minimum paid up capital of a public company, it is 5 lakh. But in case of private company, it is what? It is 1 lakh. Okay. Restricts the right to transfer its shares. Yes, in private company, you can't transfer the shares from one person to another, and limits the number of its members to 200. Okay, and except in case of one person company. So number of shareholders can be only 200, but in case of public company, it is unlimited. Okay. Prohibits any invitation to the public to subscribe for any securities of the company. Yes, in case of a private company, a private company cannot invite public to subscribe to their shares. In case of public, they can invite public to subscribe their shares, but private companies are not allowed to do that. So this is the definition which is given by the Companies Act 2013 under the section 2 subsection 68. Now we will move on to the advantages and disadvantages of private company. Okay. The first one is shareholders are only limited by the value of shares they hold. Yes, whatever the value of their shares is, to that much amount only they are liable to pay the liability. That is the meaning here. Okay. Next advantage is separate legal entity. Yes, in the same way as a separate legal entity, the company can sue and can be sued in its own name. Okay. Next is growth and expansion. See, growth and expansion can be achieved since there are more sources of capital. A private company can have capital from various other sources, so there are chances of more growth and expansion. Next comes requires less minimum capital as compared to the public company. We have seen that in a public limited company, you required 5 lakh as a minimum capital. But in case of private company, you just need only minimum capital of rupees 1 lakh. Next comes minimum 2 members are required to form a private company. Yes, in case of a private company to be formed, you require only 2 members. But if you compare this to a public company, they require 7 members. So this is one advantage of forming a private company. Next comes more sources of capital as compared to sole proprietorship and partnership forms of business organization. See, the public-private limited company has more sources of capital as compared to the sole proprietorship and partnership forms of business organization. This is because it has a higher limit of 200 people who can co-own the business and make financial contributions, compared to the limit of 20 people in the partnership and 1 person in the sole proprietorship. That is why it says that more sources of capital as compared to the sole proprietorship and a partnership form of business. Okay. Now we will see the disadvantages. The first disadvantage is it restricts the transferability of shares by its articles. Yes, in case of a partnership, the member cannot transfer his shares to the another member. But in the public company, it is allowed. So this is the first disadvantage of the private company. The next disadvantage comes, it cannot issue prospectus to the public. Yes, I have said earlier also that a private company cannot issue shares to the public. So there is one, this is the second disadvantage of the private company. The third comes, securities in public offer to be listed in stock exchanges is not applicable. So the securities which are made to the public are not allowed to be listed in the stock exchanges. Okay. And the last one is there is a restriction on maximum number of members. Yes, in the case of a private company, there is a restriction on maximum number of members, that is 200. But in case of a public company, it is unlimited. So this is the fourth disadvantage. So these were the advantages and the disadvantages of a private company. Okay. Now we will see the special privileges and exemptions available to private company. What are the special privileges and the exemptions are available to a private company in comparison to a public company? The first one is membership. See, it may have only 2 members or 1 member in case of 1-person company to form a private company. So this is one privilege which is given to the private company. Next comes number of directors. See, the minimum number of directors required to form a private company is only 2, which is lesser in number as compared to your public company. Next comes commencement of business. See, it can commence its activities immediately after the incorporation. जैसे ही you receive the incorporation certificate, a private company can commence its business. Certificate of commencement of business is not necessary, but commencement of declaration is required to be filed. But in case of public company, you cannot start your business after receiving the certificate of incorporation. Okay? So this is one of the privileges enjoyed by a private company. Next comes share capital. See, it may issue share capital of such kinds, in such forms and with such voting rights as it may think fit. So according to its need, it can issue the share capital. Next is prospectus. Shares can be allotted by a private company without issuing a prospectus. In a public company, it is necessary to issue prospectus, but in a private company, shares can be allotted by the private company without issuing a prospectus. Next comes statutory report. No statutory report is required to be filed with the registrar of companies. रजिस्ट्रार ऑफ कंपनीज को कोई भी आपको स्टैट्यूटरी रिपोर्ट फाइल करने की जरूरत नहीं है इन द केस ऑफ अ प्राइवेट कंपनी, बट इन द केस ऑफ अ पब्लिक कंपनी इट इज necessary, or you can say it is compulsory. Next comes quorum. If articles don't provide for quorum of large number, it is 2 members personally present for the meeting. Quorum means the number of people should be present in the meeting. So in case of private company, only 2 members are required to be personally present in the meeting. That is the meaning of quorum here. Okay. Next comes easy to raise capital. With the number of members being increased to 200, it will increase the ability of private companies to raise the share capital or to raise the capital. Okay. Next comes general meetings. See, the provision of the section 101 to 107 relating to the holding of general meetings are not applicable to a private company to the extent to which the company has made its own provisions in its articles. So in other words, a private company may hold its general meetings by giving a notice shorter than 21 days. So that is, it is not compulsory to hold a general meeting for a private company, or it can hold according to its provisions in its articles. Okay. The last one is management remuneration. The rule of maximum managerial remuneration is not applicable to a private company which is not a subsidiary of a public company. Okay. So this is the last privilege which is enjoyed by a private company. First one, membership, number of directors, commencement of business, share capital, prospectus, statutory report, quorum, easy to raise capital, general meetings, and the last, management remuneration. Okay. Now let us move on to the distinction between a private company and a public company. Means what is the difference between a private and a public company, we will see. First one comes number of members. In case of private company, minimum 2 and maximum 200. And in case of one person company, only 1. In case of public company, it is minimum 7 and maximum there is no limit. Next point of distinction is transfer of shares. In private company, it is restricted by articles, but in case of public company, shares are freely transferable. Name of the company, private limited as a last word. If a company is a private, then it has to put as a last word written as private limited, and if a company is a public, then it has to put the last word as public limited. Okay. Now next comes public issue of shares. See, it prohibits invitation to the public to subscribe for any securities of the company. So in private company, there is a prohibition on the invitation of the public to subscribe its shares. But in case of public company, it can invite general public to subscribe the securities of the company. So these were the 4 first distinction points. Now let us move on to the next. Fifth comes step in formation of a company. If you consider private company, only 2 steps are required to start a business or to form a company, private company. First one is promotion and the second one is incorporation. But in case of a public company, the 4 steps are there. First is promotion, incorporation, then comes your capital subscription, and the last one is commencement of business. Once these 4 steps are achieved, then only a private company can start its operation or start its business activities. Okay. Next is quorum of meeting. In case of private company, I have told you earlier, only 2 members are required to be personally present in the meeting. But in case of your public limited company, 5 in case of members up to 1000, 15 in case of members more than 1000 up to 5000, and 30 in case of members exceed 5000. Okay. Next comes number of directors and independent directors. See, number of directors here in private company is 2, and they are and there is no compulsion to appoint a independent director in case of private company. In case of public limited company, the number of directors should be 3, and in case of listed companies, at least 1/3 as independent directors. If it is a listed company, then 1/3 directors should be what? Independent directors. Retirement by rotation. This thing is not applicable to private company, but at least 2/3 of total number of directors be liable to retire by rotation and eligible of being reappointed in annual general meeting. So according to the public limited company, 2/3 of the member of directors are liable for the retirement by the process of rotation, but they can be reappointed in the annual general meeting. Okay. Now next comes paid up capital. So in case of a private limited company, I have told you earlier also, 1 lakh is the minimum capital, and in case of a public, it is 5 lakh. Okay. Rotation of auditor. See, rotation of auditor is applicable in case of private company if the paid up capital is rupees 20 crore or more, and in case of public limited company, it is applicable if the paid up capital is rupees 10 crore or more. The next point of distinction is annual evaluation in the board's report. This is not applicable in case of private company, but if paid up share capital is rupees 25 crore or more, the details of annual evaluation in the board's report is necessary for a public limited company. Okay. Next point, that is the last point of distinction, is special privileges. As we have seen earlier also in this lecture, that a private company enjoys some special privileges as compared to the public limited company. So this special privileges is not enjoyed by the public company, but there is some special privileges which are enjoyed by a private company. So these were the 12 points of distinction between a private company and a public limited company. I hope you have enjoyed or you have understand all the points mentioned in this lecture. Thank you very much.